A default judgment is a binding decision a court makes in favor of a plaintiff. This happens when the defendant fails to respond to a lawsuit. Think of it as a forfeiture in a legal game. One side did not show up to play, so the other side wins by default. This outcome can end a legal case without ever going to trial. For first-year law students, understanding the mechanics of default is crucial. It is not an obscure corner of civil procedure. It is a common and powerful tool in real-world practice. Knowing the rules protects a client's interests, whether you represent the plaintiff seeking a swift victory or the defendant trying to get back in the case. The process begins with a simple concept. A party who is sued has a duty to respond. Courts set deadlines to keep cases moving. When a defendant ignores this duty, the system cannot wait forever. The default judgment provides that resolution. The journey to a default judgment follows a clear and predictable sequence of events. Each step is governed by specific procedural rules. The first step is the filing of the complaint. This document officially starts the lawsuit. The plaintiff drafts a complaint. It outlines the facts of the dispute and presents the legal claims against the defendant. It specifies the relief sought, such as monetary damages. Filed with the clerk, a new case is opened. The complaint is the foundation of the case, and its allegations can anchor any later default. Next comes service of process. A lawsuit is not a secret. The defendant must be formally notified. The plaintiff must deliver the complaint and a summons ordering the defendant to appear. Service rules are strict to ensure fair notice. Improper service is a powerful defense against default. A court cannot exercise power over someone never properly brought into the case. Once served, the clock starts. Court rules specify a time to respond, often 21 days in federal court, 30 days in many state courts. But it can vary. A response is typically an answer or a pre-answer motion, such as a motion to dismiss. If nothing is filed by the deadline, the defendant is in default. After a defendant fails to respond, the plaintiff must secure an entry of default. This is the official recognition of the failure. Rules create two paths, one handled by the clerk, another requiring a judge. The simpler path is the clerk-entered default judgment, available for a sum certain or a sum calculable with certainty, like an unpaid invoice or a promissory note. The defendant must also have completely failed to appear. Plaintiff submits an affidavit and evidence showing the exact amount owed, with no room for estimation. For example, a $10,000 loan, no response. The clerk confirms and enters judgment for that amount, plus specified costs. Designed for efficiency, it saves court time on simple, undisputed money claims. In contrast, most cases require a court-entered default judgment, used whenever relief is not a sum certain, pain and suffering, injunctions, or hard-to-calculate damages. A judge may hold a hearing to determine damages or other relief. Liability is already established by default. A default judgment is serious, but not always irreversible. The law provides a safety valve, a motion to set aside. Courts prefer decisions on the merits and will consider a request to vacate a default. The defendant must file a motion explaining why the default should be removed and seek leave to file a late answer. Timing is critical. Typically, three things are required. First, good cause. Mistake, inadvertence, surprise, or excusable neglect. Stronger if service was improper, which can render a judgment void. Second, a meritorious defense, not proof of victory, but a plausible defense. Third, the court considers prejudice to the plaintiff. Mere delay is usually insufficient. Prejudice means tangible harm, like lost evidence or a key witness no longer available. Act quickly with a good reason and a real defense, and courts often grant relief. For plaintiffs, securing a default judgment requires careful attention to rules. First, ensure proper service. Follow the rules meticulously and file proof promptly. Second, track deadlines. Mark the response date and do not let it slip. Third, move for default quickly after the deadline. Show you are prosecuting the case. Finally, Be ready to prove damages with contracts, invoices, medical bills, and expert reports. For defendants, never ignore a lawsuit. Read everything, note the deadline, act immediately. If service was improper, raise it properly by motion. It can void a judgment. If you miss the deadline, contact counsel and prepare a motion to set aside at once. Explain your reason and show a defense in a proposed answer. Default judgment is the system's answer to inaction, ensuring lawsuits move to final resolution even when one party fails to participate. It rewards diligence, prevents paralysis, and converts uncontested allegations into an enforceable order, balanced by motions to set aside in the interest of fairness. Master the timeline, know clerk versus court, and understand set-aside standards, the bread and butter skills that will serve your clients and your career.